All right, we're not going to wait any longer. We've got several members of JPR are in the House for committee, for bill hearings, and then we've got folks rotating in and out. So we're going to be, it looks like we're going to be short 6 the entire time. So we're just going to go ahead and move forward with the bill hearings. And people can look at the recording when we're done. So we'll gavel in. All right, welcome to the Judicial Proceedings Committee. Today is Tuesday, March 29th. We have 10 bills. We'll start off with, I see there is a Senate bill here. We're not going to do that.
He's not here yet.
All right, so we're going to start off with Delegate Crosby with House Bill 34, then we'll go on to House Bill 73, 107, 176, 187, 211, 323, 833, and 1298. So without further ado, we'll start off. Actually, there he is, Senator Patterson. Sorry, you're hiding in the cut back there. All right, Senator Patterson, come on forward with Senate Bill 976. Senator, if you could come to the podium so both the cameras can catch you, and then.
Oh, you want to up here?
Yes, if that's comfortable enough for
Okay.
you. Thank you.
All right, thank you. All right. Good afternoon, Mr. Chair, Mr. Vice Chair, and members of JPR. I'm a little sniffy. I got sinuses so bad, I think I need to be home in the bed, but this work just won't turn me loose. But I do thank you for this wonderful opportunity.
And just for the record, you've tested negative on your COVID-19. So you're on the floor, so just for the record, so everyone knows, all right.
Okay, I'll take that as a plus. Is that what you said, Mr. Chair? I didn't hear the comment clearly, so I can't respond to it. What was it?
Oh, just making sure everyone knew that in order to get onto the Senate floor, you have to test negative for COVID-19.
Oh.
So you were on the floor today, although you're under
Yes,
the weather slightly,
had a
you're
test
not.
like this
positive.
morning.
Yep, there you go.
Okay, all right. Well, thank you again. And I'm pleased to introduce Senate Bill 976, sort of a straightforward bill. It established a clear mechanism for when a state's attorney may seek a sentence reduction for a currently incarcerated person, and when such a sentence reduction may be in the interest of justice. And let me just say up front, the state's attorney for both Prince George's County and Montgomery County fully supports this bill. The bill would allow, again, the state's attorney office at any point during the period of a person incarceration to file a motion with the court seeking a reduction of that person's original sentence. I think we know that there come times when individuals do get themselves rehabilitated, or the present law shifts such that it might warrant a second review. And that's basically what this bill is all about, is if the opportunity presents itself and the mechanism for the state's attorney to initiate such a request, then this type of situation could take place. This would not eliminate in any way what is currently being carried on under the courts as of today. It's simply just open up the avenue to give those who may have been incentivized or rehabilitated through any type of mechanism that the correction center might have available. And under no circumstances would anyone, the courts, be required. It's just that they would have an opportunity to be granted a request for review. That's the way I said it. I'm not a lawyer, so you guys probably can do all the chopping out. But thank you. Thank you, Mr. Chair and committee members. And if there's some burning questions, I will refer them to, I would try to explain them. If not, I'll get the answers for you. Thank you.
Sure, I appreciate it. Thank you, Senator. Questions from the committee? We have Senator Watson.
Well, so you better.
I just have one question, Senator
Yes, sir.
Patterson. So now that the General Assembly has taken the governor out of decisions related to parole and probation, is this bill still needed, and if so, why?
Well, this wouldn't cover all the type of sentences that might go. I think the one you're talking about, was that a life parole sentence that we dealt with under the other one?
You mean with the governor?
Yeah.
No, he's taken out of all decisions now related to parole and probation, correct?
I don't know, you may be ahead of me, but having served as a parole commissioner, it was not there when I was there, so I'm going on past experience.
Okay, all right,
Okay.
thank you.
Okay. Thank you, sir. Thank you.
All right, thank you, Senator. All right, with that, that'll conclude the hearing for Senate Bill 976. Now we'll go on to Delegate Crosby with House Bill 34. Welcome.
Welcome. It's good to, oh, I'm sorry. Come on. This is crazy. Let me calm down a little bit. Anyway, this is the serious treatment over here. We don't have anything like this in the house. Good to go? All right. Good afternoon, Mr. Chair, Vice Chair, members of the committee. For the record, Delegate Brian Crosby here to present House Bill 34, which is titled Criminal Law Indecent Exposure Within the Sight of the Minor. So the impetus behind the bill is that we had an individual in my area who was jumping out from behind the bushes and exposing himself to children. And then eventually, when it came time for his punishment, he was punished, but the maximum that was thrown at him still allowed him to keep his security clearance. And then that individual, after he paid his punishment, was able to then move to a different state, keep his security clearance, and then was able to continue to obtain a six-figure salary on a military installation because he was able to keep his security clearance. So that is really the impetus behind it. 15 states across the country, indecent exposure penalties are enhanced when committed against the sight of a minor. In two of our neighboring states, which are Virginia and Pennsylvania, the penalty goes from a Class 1 misdemeanor to a Class 5 felony, or from a second-degree misdemeanor to a first-degree misdemeanor, respectively, when committed against a minor. And that essentially translates to a double cap or any fine or jail sentence imposed in both of those states. This bill, after being amended by the Judiciary Committee, which I worked closely with and I thank and appreciate, increases the potential imprisonment cap from 3 to 5 years and the potential fine from $1,000 to $10,000 for indecent exposure within the sight of a minor with prurient intent. The bill only applies if the offender is more than 4 years old if the victim is older than 4 years old, and it does match the statutory rape statute. I recognize the extenuating circumstances that may certainly warrant lesser consequences. However, I believe that our courts deserve the increased flexibility when it comes to protecting our kids. So it doesn't set the floor, it just sets the ceiling. Maryland law already recognizes the importance of this issue and provides judges the option to require perpetrators to register as sex offenders if they commit indecent exposure against a minor. As a deterrent, HB 34, in its expanded alternative, is now in line with that of other states and achieves the same goal, and I ask the committee for a favorable report.
Excellent. Thank you very much, Delegate. Senator Sidnor.
Thank you. Just a question on page 2, lines 3 and 4, when it's talking about the person's prurient intent. Is the intent, is it, the intent we're talking about is to commit the crime of indecent exposure, or is it, or is your intention to say that the prurient intent is about committing the common law crime of indecent exposure, knowing that children are around to see you? Because someone that might jump out from behind a bush may not know that a child is there, but so I'm trying to figure out what your intentions are.
And I believe that is why, Senator, that the Judiciary Committee added that language to it, so it has to be sexual in nature, and that's why they added it to it. So to distinguish between your two scenarios, I would say I would I favor, or my personal intent is the latter, and I think that what the Judiciary Committee did to the bill meets that by adding that language in, because that was not in the original.
So it's the prurient intent to jump out and for children to see you exposed.
I think that prurient intent is just sexual in nature, right? So that's what it's trying to get at. It's so, if you expose yourself to, I guess the best way to describe it is if you were at a stadium, right, and you were going to the restroom and happened to be next to a child, that would not qualify under the bill, which this bill in no form ever changed that scenario. But this, adding that prurient intent, clarifies exactly what we're trying to get at. So it has to be sexual in nature. The exposure has to be sexual in nature to the child.
Meaning you just, and I'm trying, because I can remember growing up one day, driving through a neighborhood, and there was a gentleman who was standing next to a bush with no clothes on, fully exposed. I think he had some sort of mental illness issues. So under that, I'm assuming he probably could have been charged with a B. A person may not commit the common law crime of indecent exposure, but it wouldn't have been. But would it have been C if within the car that I'm driving would have had a 2-year-old in it?
I do not believe that will qualify.
It wouldn't qualify.
No, and that's why I think judiciary added this language to it. So, I mean, clearly what we're not trying to do here, Senator, is capture somebody with a mental illness that is standing on the side of the road without any clothes, right? We're trying to get somebody who is actively trying to expose themselves to a minor. So I think that language, from my understanding, and I can follow back up with you to make sure that that's exactly what judiciary, but I work closely with the subcommittee chair on that, and I think that what we were trying to exclude is haphazard situations that weren't sexual in nature, like you described. Sorry.
So a 2-year-old that's in the car. I'm fine, thank you.
Okay.
I know you want to ask, but it's tough on camera, isn't it? Yeah. Yeah. Okay. All right. So I know the impetus was a security clearance thing, and I know that obviously that's a federal, I mean, so Congress promulgates guidelines, adjudicative guidelines. There are 13 adjudicative guidelines that determine whether someone's suitable for security clearance, and that's by OPM and whatever intelligence agency that's going to go through that process. And I know that, and it's not like no conviction on your record and is like dispositive of an outcome for that. And then there's like the whole person analysis, like the 13th guideline just requires that you've got to take everything into circumstance. So I wonder, I know that we're jacking up some penalties here, and I get that on this side of the house, but do you think that that's going to have an impact for those administrative hearings for whether someone's going to be qualified to have a security clearance? And that's the intent, is that would
is the
attach?
intent, and I do believe, having spoken, obviously, working in this field, I've spoken with several members from OPN that do the security clearance background checks, and this is how we arrived at that cap to increase the penalty.
I think you're right. I mean, I've represented people that have drug convictions, things for child pornography, things like that. I've never represented someone with child pornography, just to be clear. But I think I've seen enough of those hearings that I think you're right on that.
Yeah, and to be clear, Mr. Chair, I mean, I'm only trying to do this for this very limited circumstance, right? There's other people who have had issues in the past, and obviously we have over-penalized those people. And, we're not trying to have this catch-all where we're just continuing to add on punishment after punishment, right? It's just in this limited situation where it involves a child, this specific act, I don't think somebody should be able to keep their clearance.
All right, excellent.
All right, thank you so much.
Hey, thanks a lot. Good to see you.
You too.
All right. And with that, that'll conclude the hearing for House Bill 34. Now we'll move on to Delegate Lewis with House Bill 73.
Thank you, Mr. Chair. Esteemed Senate colleagues, good afternoon. Delegate Robin Lewis here on behalf of House Bill 73, Baltimore City Complete Streets and Safe Routes to School Program funding. I'll start by speaking from the heart. This is a bill that will do two things. It will allow Baltimore City to stand on its own 2 feet, to leverage, to raise, to generate funding for pedestrian safety programs. That's number one. And anything that furthers Baltimore City's ability to stand on its own 2 feet, I think we could all get behind. And the second thing that this bill does, it creates a dedicated revenue stream for Baltimore City's pedestrian safety programs. This is a local bill. It will direct automatic traffic camera citation revenues directly to the cost of running the camera program, and then anything that's left will go to what we call our Complete Streets program, and funds can also be made available for the Safe Routes to School initiative. This matters because people matter. Their safety, their mobility, their freedom to move around without fear of getting run over is important, not just for public health, but for our city's economy. The bill before you is and in its posture, the posture that's before you, is supported by the Baltimore City House delegation, by the administration of Mayor Brandon Scott, by the Maryland Department of Transportation and MTA, by the Maryland Transit Caucus, Maryland Legislative Latino Caucus as well. The bill has no fiscal note. Again, it's a revenue bill. I won't dive into definitions about complete streets because you guys have heard this bill before and you're all jazzed up and passionate about creating streets for people just like I am. I will just remind you that this is a local bill and it's very much wanted by our city. With that, I'll end my testimony and urge a favorable report. Thank you.
Excellent. Thank you, Delegate. Well, thank you for bringing the bill before us. Just one question to either Senator Carter or Sidnor is, do you need a Senate delegation? Are you all going to meet again, or do you have a Friday? Okay.
Yes, ma'am.
Excellent. All right. Thank you very much.
Thank you so much.
All right. All right, with that, that'll end the hearing for House Bill 73. We'll now move on to Delegate Holmes with House Bill 107.
Good afternoon. How are you this afternoon? I am here to present to you House Bill 107. And Mr. Chair, if you would allow me to, although I don't usually read anything relevant to my testimony, I would like to start out by looking at a paragraph from the Montgomery Village Foundation, which was sent to you dated March 25th and signed by the Executive Vice President of the Montgomery County Foundation. And the letter starts out addressed to you, Mr. Chair, and the second paragraph, and I quote, "Mr. Chairman, there's no more important bill to Maryland common ownership communities this year than HB 107, and end quote. And with that, Mr. Chair and members of the committee, in my testimony emailed to you, you were sent a editorial by the Baltimore Sun, which was dated July the 7th, 2021, and in that editorial from the Baltimore Sun this past year, it talked about the collapse of a condominium in Florida. I also sent to each of you in that email a news clip from WUSA Channel 9 News showing some of the results of small communities not looking at and paying into their reserve study funds and what could potentially happen, particularly to a smaller community. The community that was in the news clip from Channel 9 was a 24-unit townhouse community. You also, members of the Judicial Proceedings Committee, have letters of support from the Office of Attorney General, MDE, and Community Association Institute. This is a reserve study bill ladies and gentlemen, and you are very familiar with this particular legislation as you have seen it many times in the past. And because of the frequency that you have seen it, Mr. Chair, I will end my testimony and will take questions because I think the repetitive nature of you hearing it, you probably understand well what it does and what the reasonings for it is. So with that, Mr. Chair, I will end my testimony and will take any questions that any of you may have.
Questions from the committee? All right, seeing none, I would just ask that for the Montgomery Village Foundation, we don't have it, I don't have the written testimony in the packet, so I think, is it Josh or Heather? So for the Montgomery Village Foundation letter, that would be a really great letter for me personally, being from Montgomery County, it'd be great, but
Yes.
if you could send it to us, email it to us, that'd be great.
That would be fantastic, yes. It's dated March the 25th. I will make sure you get that.
Excellent. All right, seeing no questions, thank you very much, good to see you.
Thank you.
All right, thanks. With that, that'll end the hearing for House Bill 107. We'll now move on to Delegate Carden with House Bill 176.
Good afternoon, Mr. Chair, members of the committee. For the record, John Carden on behalf of House Bill 176. This bill obviously came over favorable with amendments from the House. It does not have a cross file, and I would ask you for a favorable report on it. The bill came over as an allowance for the increase of the ability for sheriffs to be able to get reimbursed for service of process from $40, which is right now the law, to $60. There was some unfavorable testimony, primarily from advocates in the landlord-tenant area. We made sure, because the intent was never to do anything that would make it more difficult for the tenants in this situation, this environment. So we deleted out and struck all the language that would pertain to any increase in sheriff's reimbursements for anything having to do with landlord and tenant. That was done in the House. It came over, it should have come over with no unfavorable testimony. I am unaware of any testimony that came over unfavorable. If there is any, I'm sure somebody will let me know. In this time when I'm just trying to make sure that the services that these folks do is properly reimbursed so that they can at least try to. They're still not going to break even on it with the amount of time that they spend on the process work, but at least give them an opportunity to try and come close to breaking even. Sometimes they have to go and visit in person 4 or 5 times, and the amount of time it takes, certainly $40 is not sufficient. $60 is not sufficient, but hopefully this is just a little bit of help. That's the bill.
Questions for the sponsor? Seeing no questions, thank you, Delegate, for bringing the bill. Delegate Terrassa.
Great. Good afternoon. Not sure how this works. Good afternoon, Vice Chairman Wallstreicher and members of the Judicial Proceedings Committee. Thank you for this opportunity to present House Bill 187, which would eliminate probate fees in small estates, correct a regressive probate fee schedule, and make a series of needed clarifying changes. For the record, I'm Delegate Jen Terrassa. As a reminder, probate fees are not estate taxes. They are fees collected by the Register of Wills to cover cost of services performed by that office. Think of them as court filing fees. Unlike estate and other taxes, which are collected by the Comptroller's Office, probate fees are collected by the Office of the Register of Wills in each county. They are based on the value of the probate assets, which are only those assets titled in the sole name of a decedent. It doesn't include those assets that are jointly held, like a home that's jointly held, or a jointly held bank account, or have designated beneficiaries like a life assurance policy or annuities. Those items would not be part of a probate estate. So the problem is the current probate fees on small estates, which range from $2 to $150, can be a barrier to probate for very small estates, preventing heirs with limited means from being able to inherit the family car or house in some cases. Current probate fees, which haven't changed in over 30 years, are regressive. In other words, they represent a higher percentage for those with small estates than larger ones. So for example, an estate worth $5,000 pays $50, which is 1% of the value of the estate, the probate estate, whereas a $5 million estate pays $2,500 in fees, which is only 0.05% of the estate. In addition, it's my understanding from the Register of Wills that the fees for these small estates represents only about 1% of their budget for all the registers of wills statewide. And in fact, it can be more administratively burdensome to collect these fees. But however, these probate fees can amount to a lot of money for families living in poverty who have just lost a loved one. So to remedy this, House Bill 187 adjusts the current regressive fee schedule as follows. It eliminates probate fees for small estates, those under $50,000, and for those estates that are between, this is again the probate assets, are worth $50,000 to $500,000, the fee will be reduced. Over $500,000, the fees will be slightly higher to offset the reduction in revenue. However, note that in no case will the fee represent as high a percent as the small estates are paying now. As I noted before, currently small estates are paying about 1%. This bill will bring those probate fees above $50,000 to about 2% for everyone under $5 million and somewhat lower for those over $5 million. The chart in my written testimony lays out those changes, and I'm happy to answer questions. House Bill 187 actually stems from specific recommendations made by the Attorney General's COVID-19 Access to Justice Task Force. I believe you have the testimony of the Attorney General's office in support here, as well as the Register of Wills Byron McFarland, the States and Trust Law section of the Maryland Bar Association. House Bill 187 improves access to justice in the area of probate, promotes basic fairness in the fees the public is charged, and enhances efficiency in the probate process. I urge a favorable report.
Thank you, Delegate. Questions from Senator West? Seeing no questions? Just joking with you. Oh, you really do have a question. Go ahead, Senator West.
I didn't see a question.
I got it right.
He was reading my mind. Actually, I was looking at the table in the fiscal note, and it just seemed odd because things are going up and down. Under $500,000, the fees go down. Between $500,000 and $750,000, they go up. Between $750,000 and $1 million, they stay the same. Between $1 million and $2 million, they go up. Between $2 million and $2.5 million, they go down. And then they go up again after that. Is there some rhyme or reason to
Yes.
why there seems to be such gyrations in the fees?
Well, I'm looking at my chart because I had trouble seeing it visually, the way they had it in the fiscal note. But the rhyme or reason is we were trying to bring everybody to 0.2%. But then it went down a little bit up at the higher end, over $5 million, at the request of the judiciary. They wanted to see it go down a little bit faster, over $5 million. So when it goes down to I don't know if you have the blue chart that I sent.
No, I don't have that.
Along.
I've got the
I'm happy to leave you
fiscal
with-
note chart. I assume it's the same.
It is, except for that what mine includes is the fee as a percent of value of the estate being charged. So right now, it shows you that, I'm happy to send you all a copy of the chart if you haven't received it. It was in my testimony, but if not, I'm happy to send it to you. But what it does is it shows you that right now, at the lowest end, it's 1% now, it's 0.4% above that, 0.15, and it goes down to 0.05% over $5 million. The proposed fee was supposed to bring everyone to about 0.2 million. I'm sorry, 0.2%, I apologize, 0.2%. And what it ended up doing after it was amended in judiciary was it went to 0.2% and then sort of dipped a little bit at the end because judiciary had some concerns that it was going up too much.
Okay. I don't think it's a big deal. It seems to me if somebody has an estate of $1 million, paying $1,000 in probate fees isn't going to break anybody's bank.
Appreciate that.
Thanks.
There we go. Any other questions from the committee? Thank you, Delegate, for spending time with us today.
Thank you.
We'll now move on to House Bill 211, Delegate Attar. And just for the delegates who just came in, we're just going in the order in which the bills are listed today.
Thank you, Mr. Chairman and honorable members. House Bill 211 is a bill aimed at curbing gun violence. This bill does one thing and one thing only. It includes straw purchases in the list of exceptions where a police officer may arrest an individual for a misdemeanor that did not occur in their presence. Many people have asked me why I filed this bill when the judiciary notes there have been a total of 4 straw purchases in the state last year. And that is exactly why I filed this bill. I am and have been a prosecutor in Baltimore City for about 8 years. And just this year alone, I can recall several instances where a straw purchase occurred but law enforcement failed to make an arrest. Currently, in order for an officer to arrest someone immediately who conducted a straw purchase, the straw purchase would have to occur in their presence. The reality is, the chances of that happening are near to none. Rather, the already overworked officer would have to leave the suspect and then go take out charges to get an arrest warrant and sometimes only get a summons. Many times, individuals are coming in from out of state to sell these guns illegally and are far gone by the time the officer does this. To me, this crime is extremely serious. These guns are being given to children and prohibited adults and are contributing to violence in our state. So if you look at the current list of exceptions, it includes, in my opinion, far less serious offenses. For example, theft less than $1,000, prostitution, and several others. This bill passed the House of Delegates via a unanimous vote. We are all tired of the constant horrific gun violence, and we must address gun violence in many ways in order to put an end to it. This bill is just one of the many ways, and I therefore ask for a favorable report. Thank you.
Thank you, Delegate. Questions for the sponsor from the committee? First was Senator Bailey, I think was first. Oh, Senator Carter, please. Okay. Senator Carter, you're up.
Thanks so much, Delegate. Your bill testimony went really quickly, and I haven't had a chance to really dig into the bill, but I saw that it was for a warrantless arrest for straw purchases of guns, correct?
That's correct.
And so I know that you have expertise because you are, outside of this, a prosecutor. And so I'm wondering what is the nexus between warrantless arrest, like why is that needed for this particular offense?
Okay, so thank you for the question. So the elements of a straw purchase, there are 3 different elements of it, and if you look at it, it's almost the chances of a police officer seeing a straw purchase take place are near to none. And so, for example, I've had a prohibited person who had a gun specifically say to the officer on body camera that I got this gun from this person, this and this person, and then that person was from Virginia, left, and the officer tries to investigate, and then life moves on. He gets another call, gets busy. This is also a misdemeanor, so they're not indicted, these cases. The officer would then have to go take out charges, then they would have to track the person down. So because the mere definition of a straw purchase is something that almost never happens in the presence of an officer, since it's a misdemeanor, this would make it much more easier to arrest that person. And again, there have been 4 total charges in the state of Maryland last year, according to the judiciary, of straw purchases. And I, along with other colleagues of mine and other people, have seen so many more take place. It's just the investigative process is not happening, partly because this is a misdemeanor. And I don't know if you took a look at the bill yet, but originally this was filed very differently. It was to change the classification from a misdemeanor to a felony. And the reason why was for very similar reasons. This way it'll give time to investigate, it'll give time to indict, it'll be handled in circuit court. It didn't change the maximum penalty. After discussions with the Judiciary Committee, they were more comfortable with going about it this route, which I believe assists with the problem that I see.
Thanks. I'm still not sure I'm clear with that. I will be. But so in the situation you're talking about, the officer is able to seize the illegal gun and arrest the person that is there in possession of it.
Absolutely. So this is not about that person. So let's say there's a minor, for example, that's in possession of a gun. This wouldn't go towards them. So that person, that minor, is likely getting arrested regardless under CR 4203 or the Public Safety 5133. That's separate. This is for the person who legally had purchased the gun and says, I'm legally allowed to have this gun, but then they go ahead and sell it to a minor on the street. So this is gear towards that individual who sells the gun, who does not have a criminal record or anything because they purchased the gun legally and it's registered legally, but then they go ahead and sell it to someone who's prohibited from having it. Does that make more sense?
Somewhat, thank you.
Sure.
Thank you very much, and I'm just catching up. Sorry, I was testifying on some bills in the House.
No worries.
As far as the crime of a straw purchase, does that involve just handguns, or does that involve long guns also?
No, all forms of guns that you're selling to someone who's prohibited.
So a person that's prohibited?
Yes.
So that means somebody, in order to have made a straw purchase, that person would have to have been convicted of a crime for more than 2 years and a day?
Or be a minor.
Or be a minor?
Yes.
And if they were not a prohibited person and they were not a minor, would this law exist?
No,
Would this law pertain to them?
No, so if you take a look at, no, I don't have it in front of me, I apologize, but no, it's if you're selling it to a prohibited person, specifically a prohibited person.
Okay. Because the only, I see that it says knowingly being a participant in a straw purchase of a regulated firearm.
Yes.
Right, which I regulated firearm under 5141 of the public safety article. I thought that was just handguns, or ARs.
I believe it could be like a barrel that's shaved off and things like that.
Okay.
Yeah.
Okay, all right. Thank you.
Sure.
Other questions for the sponsor? See no questions. Thank you, Delegate Attar.
Thank
We
you.
appreciate your time here today. Next is Delegate Polakovich-Carr, HB 323. Thank you for being here.
Good afternoon, Mr. Vice Chair, committee members. Pleasure to be before this committee for the first time. For the record, I'm Delegate Julie Polakovich-Carr, here to present House Bill 323. This bill would ensure that every Marylander can summon the police, the fire department, or emergency medical services when they need it, and not fear retaliation by their landlord or their local government. The bill does two things. First, this bill addresses local nuisance laws, also known as crime-free housing ordinances, that fine repeated use of emergency services. These ordinances were enacted in certain jurisdictions in Maryland in the hopes of addressing repeat criminal activity at particular properties. However, some of these local laws are drafted so broadly that they end up punishing people who did nothing wrong and who legitimately need emergency services. There are a small number of municipalities and counties in our state that have enacted nuisance laws that address criminal activity on the property. These local laws vary in terms of how they define a nuisance, but most are based on documented criminal activity, such as police reports, arrests, or convictions. Local laws based on these standards are not the subject of this bill, nor are local laws that address the physical maintenance of a property. Rather, this bill is focused on local nuisance laws that are triggered by calls for police service. In those cases, the local government will fine the property owner for as little as 2 calls for police service to the property within 30 days. And if there are repeated infractions, the property owner can lose their rental license and/or use of the property for up to a year. But usually it doesn't reach this point because a landlord will evict the tenant after the first call for service, rather than risk a fine or loss of their rental license. The second part of the bill ensures that landlords are not using lease language that punishes tenants for solely calling 911. There are numerous valid reasons why someone would call the police, first and foremost because they are the victim of a crime. Someone who is seeking help from the police shouldn't be at risk of losing their home. And I think that we can all agree that we want people to report suspicious activity to law enforcement because it makes our communities safer. Nuisance laws stifle that flow of information. There are a multitude of examples of where innocent Marylanders have been harmed. For instance, people with mental health issues who accessed mobile crisis services have subsequently lost their housing. Marylanders with physical disabilities who had accidents while cooking have been evicted after the fire department was called out, even when there was no physical damage to the apartment. These local laws and lease provisions also punish people when their neighbors act as good Samaritans. For instance, someone might be concerned for the well-being of a neighbor who's in an abusive relationship, but that call to police could end up costing the victim of domestic violence her housing. As noted by Maryland's Office of Crime Control and Prevention and the U.S. Department of Housing and Urban Development, nuisance laws are discriminatory against several protected classes of people, including people of color, victims of domestic violence, LGBTQ+ individuals, and people with disabilities. To that end, a number of lawsuits have been successfully litigated against municipalities in other states because of their enforcement of a nuisance ordinance. This bill would ensure the rights of residents to get help from emergency services by barring local nuisance laws from penalizing residents and landlords for solely summoning assistance. Specifically, using the number of calls for police or emergency service as part of the definition of a nuisance property would not be allowed under the bill. Local governments, however, could still have a nuisance law that is based on a different standard, such as police reports, arrests, or convictions. 9 other states, including Pennsylvania, Louisiana, and California, have passed similar legislation. The bill also prohibits a landlord from evicting or threatening to evict a tenant solely based on the summoning of police or emergency assistance. 11 other states, including New York, Texas, and Arizona, plus DC, have passed similar laws. Notably, both advocates for renters as well as landlords support the bill, as does MACO. Thank you for your time and consideration.
Thank you, Delegate. Senator Huff.
Yeah, where is the exemption for police reports in this bill?
So it's not specifically outlined in the bill. Instead, if you look, I believe, at pages 4 and 5 of the bill, it speaks to ordinances that are based on a threshold of calls for service. So any ordinance that's not based on calls for service would be fine, and actually most jurisdictions in Maryland that have enacted nuisance laws to address criminal activity don't use calls for service.
They don't use calls for service, they use what?
They use police reports, arrests, or convictions as the threshold for defining a property as a nuisance property.
Okay, so they use police reports. I'm trying to figure out where, does anybody currently use calls for service now, any local governments?
Yes, there are a very small number, and if you'll excuse me while I pull up that list for you. There are currently 5 jurisdictions in Maryland that I'm aware of that use calls for service. Anne Arundel and Hartford counties do, although neither of those jurisdictions are actually using their laws and have not used it in recent years. And then there are 3 municipalities, Frederick, Hagerstown, and Smithsburg.
Okay, I don't represent Frederick, but it's obviously I represent Frederick County, so I'd be interested to know if they use it or not. So for example, if you have Frederick, if you have somebody was called, if somebody's called there 100 times or whatever, under this, they can't use that, but they could use, if there are 2 police reports, they could use that and say that's a nuisance and remove them then.
That's
is what
correct.
you're saying. Okay, thanks.
Other questions for the sponsor? Seeing none, thank you, Delegate, for joining us today. Appreciate your bringing the bill. Delegate Learman, come on up. House Bill 833, please.
Good afternoon, members of JPR, Mr. Vice Chair. It's great to be here with all of you. It's been a while. So in 2017, the Maryland Safe Harbor Work Group, chaired by Governor Hogan's Secretary of State, John Wobensmith, issued a report on how to ensure that Maryland is a state that supports survivors and victims of sex trafficking and helps to reintegrate them to be successful survivors. Out of that work group, they issued this report, and Senator Lee and I brought legislation that was based on the top recommendations of that report to offer safe harbor for youth victims and to set up a system of regional navigators who would ensure that no victim or survivor fell through the cracks. So part of that bill passed to set up the system of regional navigators. States attorneys and others expressed some concern that the regional navigator system was not yet in place, and so wanted to save the safe harbor provisions until after the regional navigator system was set up. Well, we set up the regional navigator system. It has been up and running now for several years, and so that any safe harbor provision should not be can go into effect. So now we are in a place where we are excited to bring HB 833. This is a bill that strengthens Maryland law to support juvenile trafficking survivors by recognizing the impact of their trafficking and trauma on their behavior. The bill does a few things. It works with and requires law enforcement officers to notify an appropriate regional navigator for the jurisdiction where the victim was taken into custody or where the victim is a resident, so that service can be coordinated. It prevents a law enforcement officer from detaining a victim taken into custody in a juvenile detention facility. It requires a court to stay all proceedings and employ a regional navigator to evaluate a victim's status as a survivor of sex trafficking, and requires a court to dismiss a case and refer victims to DHS if a regional navigator finds that the victim committed a violation as a result of being trafficked. This bill is really, I believe, the right thing to do. We'll join over 40 states that already do this. It will lead to better outcomes for trafficking victims, improve resiliency for survivors, and ensure our justice system is focused on true offenders and not on victims. HB 833 passed the House of Delegates 126-5, and I ask for a favorable report. Thank you.
Thank you, Delegate. Yes, Senator Huff.
I'm just looking at, looks like the Maryland judiciary, it appears even as the way you amended it out of the House. Have you seen their testimony that they oppose?
Yes, so I just saw it. They had previously had some testimony in the Judiciary Committee, and we made a lot of changes to the bill that we thought would satisfy everything they needed. We did reach out to them to meet, and we got no response. So I think that their concerns are not entirely founded. So one of the things they note is, they question what will happen to the child if the assessment of the regional navigator is pending or if the assessment's challenged. But the bill requires dismissal of a case if it's determined that a child is a victim of trafficking and the underlying charge is a qualifying offense and was committed as a result of that trafficking. So I don't, when a child's in detention or community detention, there's judicial discretion around that. And so I don't actually think that's a concern because of how things already are. They also note that there's not identified criteria or time requirements for the navigator's assessment. That's just not true. On page 6, lines 10 to 13, the bill states that the court has to schedule a hearing within 15 days after a motion is filed and may extend the time an additional 15 days upon good cause shown. Starting on page 6, line 14, the bill goes on to state that the court will determine, by evidence presented on the record and by a preponderance of evidence whether a child is a victim. So, I appreciate their interest. I will note that they support the intention of the bill and that we've made numerous changes based on previous statements that they have put in, but I don't think that their concerns are actually going to be realized.
I have a lot of bills that the judiciary supports the intent, but their letter usually
Yes.
reflects otherwise. Just
Yes.
one question is also, it looks like DHS did a letter of information, but there's, basically, it looks like some technical type amendments they want. Have you had a chance to look at that too?
I haven't seen theirs for the Senate. They had a letter of information in the House, and I don't know if it's an identical one, but we worked pretty closely with them on the issues that they had in the House to update the bill and clarify language to close the gaps close some of the gaps that they saw.
You might want to take a look at it because
Okay.
there's a couple, looks like technical, there's 3 points they make here and they cite the wording and stuff like that.
Okay.
So you might want to take a look at that.
Yeah, we'll take a look. Happy to take a look. Great.
Thank you, Senator. Other questions for the sponsor? So we are sponsor only, but I note that the advocates are here. Does anyone have any genuine technical questions for the advocates? Given how fast we're moving, I just want to give that opportunity. Okay, seeing no questions, that concludes the hearing for House Bill 833. Thank you, Delegate Learman.
Thank you all.
The final bill for today is House Bill 1298. Delegate Grist.
Thank you all, and I'm standing in your way for leaving, so I'll be as brief as I can here. And so we in the when bill went to the floor last week, there was a little bit of a laugh at my expense. So this is obviously I'm from the minority party, and this is an expungement bill, and so bear with me here. And it did pass, although at a there's a big difference between obviously what the bill came in and what came out of the House, and so I'll talk about that very briefly. So the intent of the bill. I don't know if you guys remember or not, back in 2019, we did pass a bill out of both houses, and it went into law that expunged boating violations. And so what we tried to do with hunting and fishing is we tried to align hunting and fishing with boating. So what that basically did, one is it allowed the DNR violations in both hunting and fishing the opportunity to go from 10 years, as that's what's under current law in the criminal code, to 3 years, assuming that their license hasn't been revoked or if they haven't committed any subsequent charges. Or they would have to wait another 2 years to make it 5 if their license was revoked. And then they would have to wait 10 years if they've had multiple violations. And so what ended up passing, it was completely stripped out, and so really what we have now is just some very narrow scope of potential charges that could be expunged in both hunting and fishing, and they're actually listed in the fiscal note. It's things like hunting without a license, the possession of a license while hunting, duty to present a license to law enforcement on demand, hunting wild game birds without a migratory game bird stamp, training a retriever dog, using artificially reared game birds without a permit, failure to wear fluorescent clothing, trapping fur bearers without a license, waterfowl from a blind site without a license, engaging in specific activities without a falconry permit. So, obviously there was this is a very, very limited scope. And here I am, obviously, from the minority party, trying to explain to this committee why expungement is so important. I did the same over on the House side. Obviously, we all make mistakes, and for us, these are just misdemeanors that was originally in this bill. We're not talking about major offenses. We're talking about minor crimes, where someone had to wait 10 years. And so, so I'm just going to ask, certainly this committee, if we could try to align this bill with how it was originally intended from the beginning. And I will say, in full disclosure, that I believe, and no one else testified in opposition in the House, but there was, and you'll probably see it in your written testimony, some opposition, probably by the Chesapeake Bay Foundation and some others. And I think what their concern is that we're going to be too lenient on folks who are going to poach on oyster sanctuaries, possibly. And so I'm hoping that we can come up with some sort of compromise. But obviously there are a lot more violations, small violations that folks commit every single day. If they wait more than 3 or even 5 years, hopefully that their record would be expunged at some point, because I can tell you that it's an easy to do a case search. I've had back home folks that weren't able to take their kids on field trips, to chaperone on field trips. They wouldn't let them do it because there's a DNR violation on their criminal record. So obviously it does have a meaningful impact, on people's lives, and so I'll be happy to take any questions.
Good afternoon. Quick question. It came out the House, if this bill were to come out of this committee, will we put you in danger of being called soft on crime?
Well, if we're talking about misdemeanor crime, then yeah, I'm a little soft on misdemeanor crime, yeah. I think everybody in this room has probably made a mistake or two at some point in their lives, especially when you're younger, yeah. You're absolutely right.
And you voted, I'm assuming you voted for some of our expungement bills that we've had over the years?
I did not.
Very good. That's all. Just thank you.
I'm not gonna lie although I did not take an oath here. No, he's fine. No, I get it. No, I had this line of questioning everybody. Yeah. All right. That's right.
Thank you, Mr. Chairman. Can you just walk through, so it's 5 years and 10 years for different offenses? Is that right?
Well,
That
under
you can
current law, it's
expense?
10. I believe is the time that it can be expunged. And actually, if it's a DNR violation, I don't know that it can be expunged at all, I believe. I'm actually looking for some help for Senator Bailey. I don't know that they can be expunged.
At all?
They cannot be expunged
And
at
you're
all.
proposing
If-
to
if it's-
do-
If it's in the DNR code, it cannot be expunged at all.
Okay, and you're proposing to expunge after how long?
To have it actually align with the boating law changes that we made back in 2019. So these are all just misdemeanors again.
Right.
So it would be 3 years if they had no other violations, or they have not had their license revoked. And if they have had their license revoked for whatever reason, then they have to wait an additional 2 years. And then if they've had subsequent violations, they would have to wait the 10 years, which I believe is what's in the criminal code for these violations that I just read.
Okay.
I think with how they amended it, I'm not an attorney, but I think what they amended, they just struck the DNR code, and then whatever falls in line with the criminal code is what we're going to enforce.
Okay, just curious why you picked the voting law to align it with.
Well, it's very similar. It's very similar in nature to both hunting and fishing.
Thank you.
First, I want to congratulate you, because as, I'm not exactly sure what happened, I had the exact cross file, right? And I stood up there and I testified to this committee, and not one person said a word, not one person had a question, and I'm like, wow, look how engaging you are, Delegate. So, so I wanted to say, thank you very much, and I want to applaud you on trying to, especially in our very rural communities, getting some of these people back to work, because I know how difficult it is when they lose their license. And that is something that their family's done, and they've been involved for years, that they all of a sudden can no longer be a waterman, and all of a sudden now they're a carpenter, or they're doing something completely different. And I do think we worked with Chris Dees quite a bit this summer with this bill. I would like to offer it to the committee, that I think there is a workaround with this. Maybe not as extreme as the bill first came in, but I do think there are definitely some issues, because the way it was, the way it came to us presented today, it really doesn't do anything. So, so if we have some time, I think we can maybe send something back to you that might be a little bit.
See, the senator's
more
not soft
palatable.
on crime. He called my bill extreme. Did you guys hear that?
So, thank you.
All right, guys, thank you all.
All right, thank you very much. Good to see you. Thanks. All right, with that, I think that ends the hearings for the day, and we are not voting tonight. So we get to tag off right now.